not by Section 10, but are considered essential. 1. Two parties. One cannot contract with himself. It involves at least two parties. Contract may be made by natural persons and by other persons having legal existence. Identity of parties must be ascertainable. 2. Parties must intend to create legal obligations. There must be an intention on the part of the parties to create legal relationship. Social or domestic type of agreements are not enforceable in court of law. 3. Other formalities to be complied with in certain cases. A contract may be written or spoken, but in the interest of parties, the contract must be written. Certain contracts require some other formalities have to be enforceable. 4. Certainty of meaning. The agreement must be certain and not vague or indefinite. 5. Possibility of performance of an agreement. Terms of agreement should be capable of performance. Impossible act can't be enforced. By Section 10 of Indian Contract Act, 1872 agreement. Every promise and every set of promises, forming consideration for each other, is an agreement. And a proposal, when accepted, becomes a promise. 2. Free consent. Two or more persons are said to consent when they agree upon the same thing in the same sense. Consent would be considered as free consent if it is not caused by coercion, undue influence, fraud, misrepresentation, or mistake. 3. Capacity of the parties. Capacity to contract means the legal ability of a person to enter into a valid contract. Every person is competent to contract who A. is of the age of majority according to the law to which he is subject, and B. is of sound mind, and C. is not otherwise disqualified from by any law. Qualification. A. Person entering into contract must be of 18 years of age. Persons below 18 years of age are considered minor, therefore incompetent to contract. Qualification. B. A person to be of sound mind, that is, he should be in his senses, so that he understands the implications of the contract at the time of entering into a contract. A lunatic, an idiot, a drunken person is not sound mind. Qualification. C. A person entering into a contract should not be disqualified by his status in entering into such contracts. Such persons are an alien enemy, foreign sovereigns, convicts, etc. They are disqualified unless they fulfill certain formalities required by law. 4. Consideration, referred to as quid pro quo, that is, something in return, may consist either in some right, interest, profit, or benefit accruing to one party, or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by other. 5. Lawful consideration and object. The consideration and object of agreement must be lawful. States that consideration or object is not lawful if it is prohibited by law, or it is such as would defeat the provisions of law, if it is fraudulent or involves injury to the person or property of another, or court regards it as immoral or opposed to public policy. 6. Not expressly declared to be void. Agreement entered must not be which the law declares to be either illegal or void. An illegal agreement is an agreement expressly or impliedly prohibited by law. 1. Valid contract. Agreement which is binding and enforceable is a valid contract. It contains all the essential elements of a valid contract. 2. Void contract. Contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Thus, a void contract is one which cannot be enforced by a court of law. 3. Voidable contract. Agreement which is enforceable by law at the option of one or more parties thereto, but not at the option of the other or others, is a voidable contract. Following is the situation where contract is voidable. I. Consent is not free under coercion, undue influence, misrepresentation, or fraud. 2. If a person promises to do something for another, but other person prevents him from performing his promise, contract becomes voidable at the option of first person. 3. When a party to a contract promised to perform a work within a specified time, could not perform within that time, contract becomes voidable at the option of promise. 4. Illegal contract. It is a contract which the law forbids to be made. Void ab initio and can't be enforced. The court will not enforce such a contract, but also the connected contracts. All illegal agreements are void, but all void agreements are not necessarily illegal. 5. Unenforceable contract, where a contract is good in substance but because of some technical defect that is absent in writing, barred by limitation, etc., one or both the parties cannot sue upon it. 2. Implied contracts. The contract come into existence by implication, that is, by action or conduct of parties or course of dealings between them. Tacit contracts. The word tacit means silent. Tacit contracts are those that are inferred through conduct of parties without any words spoken or written. 3. Quasi-contract. Quasi-contract is not an actual contract, but it resembles a contract. Law creates and enforces legal rights and obligations when no real contract exists. Such obligations are known as quasi-contracts. 4. E-contracts. If contract is entered using electronics means, it is known as e-commerce contracts. 1. Executed contract. When the act is done or executed or forbearance is brought on record, then the contract is an executed contract. Consideration is the act or forbearance. 2. Executory contract. In an executory contract, consideration is reciprocal promise or obligation. It is to be performed in future only, hence described as executory contracts. 1. Unilateral contract. It is a one-sided contract in which one party has performed his duty or obligation, and other party's obligation is outstanding. 2. Bilateral contract. It is one where the obligation or promise is outstanding on the part of both the parties. Offer. Definition. When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. Classification of offer. 1. General offer. Made to public at large, and hence anyone can accept and do the desired act. Anyone performing the conditions of offer can be considered to have accepted it. Until the general offer is retracted or withdrawn, it can be accepted by anyone at any time as it is a continuing offer. 2. Special/specific offer. Made to a specific or an ascertained person. It can be accepted only by that specified person to whom the offer has been made. 3. Cross offer. When two parties exchange identical offers in ignorance of each other's offer, the offers are called cross offers. There is no binding contract in such a case because offer made by a person cannot be construed as acceptance of the another's offer. 4. Counteroffer. When offeree offers to modifications and variations in the terms of original offer, he is said to have made a counteroffer. It amounts to rejection of original offer, also called as conditional acceptance. 5. Standing or continuing or open offer. Offer which is allowed to remain open for acceptance over a period of time, essential of a valid offer. 1. It must be capable of creating legal relations. Offer must be such as in law is capable of being accepted and giving rise to legal relationship. If not, then it is not a valid offer in the eye of law. Social invitation accepted does not create legal relations because it is not so intended. 2. It must be certain, definite, and not vague. If terms are vague or indefinite, its acceptance can't create any contractual relationship. 3. It must be communicated to the offeree. Offer to be complete must be communicated to the person to whom it is made, otherwise there can be no acceptance of it. Acceptance of an offer, in ignorance of offer, is not acceptance and does not confer any right on acceptor. 4. It must be made with a view to obtaining the assent of the other party. Offer must be made with a view to obtaining the assent of the other party addressed, and not merely with a view to disclosing the intention of making an offer. 5. It may be conditional. An offer can be made subject to any terms and conditions by the offerer. 6. Offer should not contain a term the non-compliance of which would amount to acceptance. Thus, one cannot say that if acceptance is not communicated by a certain time, the offer would be considered as accepted. 9. Offer is different from a mere statement of intention. An invitation to offer, a mere communication of information, a prospectus and advertisement. 1. A statement of intention and announcement. 2. Offer must be distinguished from an answer to a question. 3. A statement of price is not an offer. 4. An invitation to make an offer or do business. 10. A statement of price is not an offer. Invitation to offer. Invitation to offer is different from offer. where a party without expressing his final willingness proposes certain terms on which he is willing to negotiate. He does not make an offer, but only invites the other party to make an offer on those terms. It is only a circulation of an offer. It is an attempt to induce offers. Acceptance of an invitation to an offer does not result in the contract. Following are instances of invitation to offer to buy or sell. 1. A prospectus by a company to the public to subscribe for its shares. 2. Display of goods for sale in shop windows. 3. Advertising auction sales. And 4. Quotation of prices. Acceptance. Definition. When the person to whom the proposal is made signifies his assent thereto, proposal is said to be accepted. The proposal, when accepted, becomes a promise and cannot be withdrawn or revoked. Legal rules. Regarding a valid acceptance. 1. Acceptance can be given only by the person to whom offer is made. In case of a specific offer, it can be accepted only by the person to whom it is made. In case of a general offer, it can be accepted by any person who has the knowledge of the offer. 3. The acceptance must be communicated. Acceptance must be communicated in some perceptible form. Any conditional or varying or too deviant conditions is no acceptance. Conditional acceptance is a counterproposal and has to be accepted by the proposer. Further, when a proposal is accepted, the offeree must have the knowledge of the offer made to him. If he does not have the knowledge, there can be no acceptance. 6. Mere silence is not acceptance. Acceptance cannot be implied from silence of offeree or his failure to answer, unless the offeree has in any previous conduct indicated that his silence is evidence of acceptance. Modes of revocation of offer. 1. By notice of revocation. 2. By lapse of time. Time for acceptance can lapse if the acceptance is not given within the specified time, and where no time is specified, then within a reasonable time. 3. By non-fulfillment of condition precedent. Where the acceptor fails to fulfill a condition precedent to acceptance, the proposal gets revoked. 4. By death or insanity. Death or insanity of the proposer would result in automatic revocation of the proposal, but only if the fact of death or insanity comes to the knowledge of the acceptor. 5. By counteroffer. 6. By the non-acceptance of the offer according to the prescribed or usual mode. 7. By subsequent illegality. Unit 2. Consideration. When at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or abstain from doing something, such an act or abstinence or promise is called consideration for the promise. Consideration may consist of either some right, interest, profit, or benefit accruing to one party, or forbearance, detriment, loss, or responsibility given, suffered, or undertaken by other. It is a term used in the sense of quid pro quo, that is, something in return. Legal rules regarding consideration. 1. Consideration must move at the desire of the promiser. Consideration must be offered by promisee or third party at the desire or request of promisor. An act done at the desire of a third party is not a consideration. 2. Consideration may move from promisee or any other person. Consideration may proceed from the promisee or any other person who is not a party to the contract. There can be a stranger to a consideration, but no stranger to a contract. 3. Executed and executory consideration. Consideration which consists in the performance of an act is said to be executed. When it consists in a promise, it is said to be executory. 4. Consideration may be past, present, or future. Consideration, if past, may be the motive but cannot be the real consideration of a subsequent promise. But if services being rendered in past at the request or desire of promiser, the subsequent promise is regarded as an admission that past consideration was not gratuitous. 5. Consideration need not be adequate. It need not be approximately of equal value with the promise for which it is exchanged, but it must be something which the law would regard as having some value. Something in return need not be equal to something given. If consent is freely given, will not be void merely because consideration is inadequate. But if it is less and other party alleges that his consent was not free, then this inadequate consideration can be taken as evidence in support of this allegation. 6. Performance of what one is legally bound to perform. performance of an act by a person who is legally bound to perform the same cannot be consideration for a contract, but where a person promises to do more that he is legally bound to do, or such a promise provided it is not opposed to public policy, is a good consideration. 7. Consideration must be real and not illusory. It must be something to which the law attaches some value. If it is legally or physically impossible, it is not considered valid consideration. 8. Consideration must not be unlawful, immoral, or opposed to public policy. Only presence of consideration is not sufficient, it must be lawful. Anything which is immoral or opposed to public policy can't be valid consideration. Suit by third party to a contract. Consideration for an agreement may proceed from a third party, but third party cannot sue on contract. Only a person who is a party to a contract can sue on it. Thus, stranger to consideration is a valid and is different from stranger to a contract. Stranger to contract cannot sue is known as a doctrine of privity of contract. It is, however, subject to certain exceptions. Stranger to a contract may enforce a claim in the following cases. 1. In the case of trust. Beneficiary can enforce his right, though he was not a party to contract between the settlor and the trustee. Pushpatar. 2. In case of family settlement. If terms of settlement are reduced into writing, the members of family who originally had not been parties to settlement may enforce the agreement. 3. In case of certain marriage contracts/arrangements, provision may be made for benefit of a person. He may file the suit though he is not a party to the agreement. 4. In the case of assignment of contract, when benefit under a contract has been assigned, assignee can enforce the contract, but such assignment should not involve any personal skill. 5. Acknowledgement or estoppel. Where promisor by his conduct acknowledges himself as an agent of third party, it would result into a binding obligation towards third party. 6. In the case of covenant running with land. Person who purchases land with notice that the owner of land is bound by certain duties affecting land, covenant affecting the land may be enforced by successor of the seller. 7. Contracts entered into through an agent. Principal can enforce the contracts entered by his agent where agent has acted within the scope of his authority and in the name of principal, validity of an agreement without consideration. Agreement made without consideration is void. Contract may be enforceable when consideration is there. However, there are certain exceptions to this rule. In the following cases, agreement though made without consideration will be valid and enforceable. 1. Natural love and affection. Following conditions must be fulfilled. A. It must be made out of natural love and affection between the parties. B. Parties must stand in near relationship to each other. C. It must be in writing. D. It must also be registered under the law. 2. Compensation for past voluntary services. Promise to compensate, wholly or in part, a person who has already voluntarily done something for the promiser is enforceable. The following essential factors must exist. A. The services should have been rendered voluntarily. B. The services must have been rendered for the promiser. C. The promiser must be in existence at the time when services were rendered. D. The promiser must have intended to compensate the promisee. 3. Promise to pay time-barred debt. Where a promise in writing signed by person making it or authorized agent is made to pay a debt barred by limitation, it is valid without consideration. 4. Agency. No consideration is necessary to create an agency. 5. Completed gift. In case of completed gifts, the rule no consideration. No contract does not apply. Gifts do not require any consideration. 6. Bailment. No consideration is required to effect the contract of bailment. Defines bailment. 7. Charity. If a promisee undertakes the liability on the promise of the person to contribute to charity, there the contract shall be valid even without consideration. 1. Contract made with or by a minor is void ab initio. Minor is not competent to contract, and any agreement with or by minor is void from the very beginning. 2. No ratification after attaining majority. As the original agreement is void ab initio, and a void agreement can never be ratified. Hence, no ratification after attaining majority. 3. Minor can be a beneficiary or can take benefit out of a contract. Though a minor is not competent to contract, nothing in the Contract Act prevents the minor from making the other party bound to him. Thus, a promissory note duly executed in favor of a minor is not void and can be sued upon by him because he, though incompetent to contract, may yet accept a benefit. Minor cannot become partner in a partnership firm. However, he may, with the consent of all the partners, be admitted to the benefits of partnership. 4. A minor can always plead minority. Minor can always plead minority and is not stopped to do so even where he has taken any loan or entered into any contract by falsely representing that he was major. Rule of estoppel can't be applied against minor, i.e., he can plead his minority in defense. 5. Liability for necessaries. Claim for necessaries supplied to minor or to any other person whom such minor is legally bound to support is enforceable by law. But a minor is not liable for any price that he may promise, and never for more than the value of the necessaries. There is no personal liability of minor, but only his property is liable. To render minor's estate liable for necessaries, 2 conditions must be satisfied. A. Contract must be for goods reasonably necessary for his support in life. B. Minor must not have already a sufficient supply of these necessaries. Necessaries mean those things that are essentially needed by a minor. They cannot include luxuries or costly or unnecessary articles. Expenses on minor's education, funeral ceremonies come within the scope of necessaries. 6. Contract by guardian. How far enforceable? Though a minor's agreement is void, his guardian can enter into a valid contract on minor's behalf. Where guardian makes a contract for minor, which is within his competence and which is for the benefit of minor, there will be valid contract which the minor can enforce. But all contracts made by guardian on behalf of a minor are not valid. For instance, guardian of a minor has no power to bind the minor by a contract for the purchase of immovable property. But a contract entered into by a certified guardian of a minor, with the sanction of court for sale of minor's property, may be enforced. 8. No insolvency. Minor cannot be declared insolvent as he is incapable of contracting debts, and dues are payable from the personal properties of minor, and he shall never be held personally liable. 9. Partnership. Minor being incompetent to contract cannot be a partner, but he can be admitted to the benefits of partnership. 10. Minor can be an agent. A minor can act as an agent, but he will not be liable to his principal for his acts. A minor can draw, deliver, and endorse negotiable instruments without himself being liable. 11. Minor cannot bind parent or guardian. In the absence of authority, express or implied, an infant is not capable of binding his parent or guardian, even for necessaries. Parents will be held liable only when the child is acting as an agent for the parents. 12. Joint contract by minor and adult. Adult will be liable on the contract and not the minor. 13. Surety, guarantor for a minor. In a contract of guarantee, when an adult stands surety for a minor, then he, adult, is liable to third party, as there is direct contract between surety and the third party. 14. Minor as shareholder. Minor being incompetent to contract cannot be a shareholder of the company. If by mistake he becomes a member, company can rescind the transaction and remove his name from register. But a minor may, acting though his lawful guardian, become a shareholder by transfer or transmission of fully paid shares to him. Person of sound mind. A person is sound mind, that is, he should be in his senses, so that he understands the implications of the contract at the time of entering into a contract. A lunatic, an idiot, a drunken person are not sound mind. Person who is usually of unsound mind, but occasionally of sound mind, may make a contract when he is of sound mind. Person who is usually of sound mind, but occasionally of unsound mind, may not make a contract when he is of unsound mind. Position of unsound mind person making a contract is void. C. Contract by disqualified persons. Besides minors and persons of unsound mind, there are also other persons who are disqualified from contracting, partially or wholly, so that the contracts by such person are void. Incompetency to contract may arise from political, corporate, legal status, etc. The following persons fall in this category: foreign sovereigns and ambassadors, alien enemy, corporations, convicts, insolvent, etc. Free consent. Two or more persons are said to consent when they agree upon the same thing in the same sense. Parties are said to have consented when they agreed upon the same thing in the same sense. Consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, mistake. A. Coercion, meaning coercion is committing or threatening to commit any act forbidden by Indian Penal Code or unlawful detaining, or threatening to detain any property, prejudice of any person whatever, with the intention of causing any person to enter into an agreement. It is not necessary that coercion must proceed from a party to contract, nor subject of the coercion must be the other contracting party. It may be directed against any third person. Effects of coercion. A. Voidable at the option of party whose consent was so obtained. B. Person to whom money has been paid or anything delivered under coercion must repay or return it. Threat to commit suicide. Whether is it coercion? Suicide, though forbidden by Indian Penal Code, is not punishable, as a dead man cannot be punished. But Section 15 declares that committing or threatening to commit any act forbidden by Indian Penal Code is coercion. Hence, a threat to commit suicide will be regarded as coercion. B. Undue influence, meaning contract is said to be induced by undue influence, where the relations subsisting between parties are such that one of the party is in a position to dominate the will of the other, and he uses that position to obtain an unfair advantage over the other. Essential ingredients under this provision are 1. Relation between the parties. A person can be influenced by other when a near relation between the two exists. 2. Position to dominate the will. Relation exists in a manner that one of them is in a position to dominate the will of other. A person is deemed to be in such position in the following circumstances. A. Real and apparent authority, where a person holds a real authority over other. Example: master and servant, doctor and patient, etc. B. Fiduciary relationship, where relation of trust and confidence exists between parties. Example: father and son, solicitor and client, husband and wife, creditor and debtor, etc. C. Mental distress. Undue influence can be used against a person to get his consent on a contract where the mental capacity of the person is temporarily or permanently affected by the reason of mental or bodily distress, illness, or of old age. D. Unconscionable bargains, where one party is in a position to dominate the will of other, and the contract is apparently unconscionable, that is, unfair. It is presumed by law that consent must have been obtained by undue influence. Example: money-lending transactions and in gifts. 3. Object must be to take undue advantage in getting consent of other. Where the person is in a position to influence the will of the other in getting consent, must have the object to take advantage of the other. 4. Burden of proof. When a party to contract decides to avoid the contract on the ground of undue influence, he has to prove that A. The other party is in position to dominate his will. B. The other party actually used his position to obtain his consent. C. Transaction is unfair or unconscionable. Effect of undue influence. I. Contract is voidable at the option of the party whose consent was so caused. 2. Such contract may be set aside either absolutely, or if party entitled to avoid it has received any benefit thereunder, upon such terms and conditions as to the court may seem fit. Definition. Fraud means and includes any of the following acts committed by a party to a contract, or his connivance or by agent, with an intent to deceive another party or his agent, or to induce him to enter into the contract. 1. Suggestion as a fact, which is not true by any person who does not believe it to be true. 2. Active concealment of a fact by one having knowledge or belief of the fact. 3. A promise made without any intention of performing it. 4. Any other act fitted to deceive. 5. Any such act or omission as the law specially declares to be fraudulent. The following are the essential elements of the fraud. 1. There must be a representation or assertion, and it must be false. However, silence may amount to fraud, or an active concealment may amount to fraud. Question: whether silence is fraud or not? Answer: silence is fraud in following situations. 1. There is duty to speak. 2. When silence is equal to speech. 2. Representation must be related to a fact. 3. Representation should be made before the conclusion of the contract with the intention to induce the other party to act upon it. 4. Representation or statement should be made with a knowledge of its falsity or without belief in its truth, or recklessly not caring whether it is true or false. 5. The other party must have been induced to act upon the representation or assertion. 6. The other party must have relied upon the representation and must have been deceived. 7. The other party acting on the representation must have consequently suffered a loss. Effect of fraud upon validity of a contract. When consent to an agreement is caused by fraud, the contract is voidable at option of the party defrauded, and he has the following remedies. 1. He can rescind the contract within a reasonable time. 2. He can sue for damages. 3. He can insist on performance of contract on the condition that he shall be put in the position in which he would have been had the representation made been true. Exception. In the following cases, contract is not voidable. 1. If the party whose consent was caused by silence, which amounting to fraud, had the means of discovering the truth with ordinary diligence. 2. A fraud which did not cause the consent of the party to agreement misrepresentation. There is misrepresentation. If 1. Statement of fact which is false would constitute misrepresentation if the maker believes it to be true, but which is not justified by the information he possesses. 2. When there is a breach of duty by a person without any intention to deceive, but which brings an advantage to him. 3. When a party causes the other party to agreement to make a mistake as to the subject matter, even though done innocently. Mistake. Mistake may be defined as innocent or erroneous belief, which leads the party to misunderstand the others. 1. Bilateral mistake, where both parties to an agreement are under a mistake as to matter of fact essential to the agreement. The agreement is void. Cases of bilateral mistakes. It can be quality/existence/identity/title/price/quantity of the subject matter. 2. Unilateral mistake. Contract is not voidable merely because it was caused by one of the parties to it being under a mistake as to a matter of fact. Legality of object and consideration. In each of the following cases, consideration or object of an agreement is said to be unlawful. 1. When consideration or object is forbidden by law. Acts forbidden by law are those which are punishable under any statute, as well as those prohibited by regulations or orders. 2. When consideration or object are of such a nature that, if permitted, not directly but indirectly it would defeat the provisions of law, agreement is void. 3. When it is fraudulent. Agreements which are entered into to promote fraud are void. 4. The general term injury means criminal or wrongful harm. The object or consideration is unlawful as it involves injury to the person or property of another. Example, Copyright 5. When consideration is immoral. 6. When consideration is opposed to public policy in the name of public policy, freedom of contract is restricted by law only for the good for the community. Some of the agreements which are held to be opposed to public policy are 1. Trading with enemy. Any trade with person owing allegiance to a government at war with India without the license of the government of India is void, as the object is opposed to public policy. Here, the agreement to trade offends against the public policy by prejudice to the interest of the state in times of war. 3. Maintenance and champerty. Maintenance is an agreement in which a person promises to maintain suit in which he has no interest. Champerty is an agreement in which a person agrees to assist another in litigation in exchange of a promise to hand over a portion of the proceeds of the action. A. It is unreasonable so as to be unjust to other party, or B. It is made by a malicious motive and not with bona fide object of assisting a claim. 4. Trafficking relating to public offices and titles. Agreement to trafficking in public office is opposed to public policy, as it interferes with the appointment of a person best qualified for the service of the public. Public policy requires that there should be no money consideration for the appointment to an office in which the public is interested. Following are the examples of agreements that are void. A. Agreement to pay money to a public servant in order to induce him to retire from his office so that another person may secure the appointment is void. B. An agreement to procure a public recognition like Padma Vibhushan for reward. V. Agreements tending to create monopolies are opposed to public policy, therefore void. 6. Marriage brokerage agreements. Agreement to negotiate marriage for reward, which is known as a marriage brokerage contract, is void, as it is opposed to public policy. Note: Marriage Bureau only provides information and doesn't negotiate marriage for reward. Therefore, it is not covered under this point. 7. Interference with the course of justice. An agreement whose object is to induce any judicial officer of the state to act partially or corruptly is void, as it is opposed to public policy. 8. Interest against obligation. Object of such agreements is opposed to public policy. 9. Consideration. Unlawful in part, if any part of a single consideration for one or more objects, or any one or any part of any one of several considerations for a single object, is unlawful, the agreement is void. There is no promise for a lawful consideration if there is anything illegal in a consideration which must be taken as a whole. Where legal part of a contract can be severed from illegal part, the bad part may be rejected and the good one can be retained. But where the illegal part cannot be severed, the contract is altogether void. 7. Expressly declared void agreements. 7. Agreement in restraint of trade. Agreement by which any person is restrained from exercising a lawful profession, trade, or business of any kind, is to that extent void. But this rule is subject to following exceptions. 1. Where a person sells goodwill of a business and agrees with the buyer to refrain from carrying on a similar business within specified local limits, so long as the buyer or his successor in interest carries on a like business therein, such an agreement is valid. The local limits must be reasonable. 2. If an outgoing partner makes an agreement with continuing partners that he will not carry on any business similar to that of the firm within a specified period or within specified local limits, such an agreement, thought in restraint of trade, will be valid if the restrictions imposed are reasonable. 3. Similarly, agreement between partners not to carry on competing business during the continuance of partnership is valid. 4. But an agreement of service by which an employee binds himself, during the term of his agreement, not to compete with his employer is not in restraint of trade. 10. Wagering agreement. Agreement by way of a wager is void. It is an agreement involving payment of a sum of money upon the determination of an uncertain event. Essence of a wager is that each side should stand to win or lose, depending on the way an uncertain event takes place. Essentials of a wager. 1. There must be a promise to pay money or money's worth. 2. Promise must be conditional on an event happening or not happening. 3. There must be uncertainty of event. 4. There must be two parties. Each party must stand to win or lose. 5. There must be common intention to bet at the timing of making such agreement. 6. Parties should have no interest in the event except for stake. Transactions similar to wager, gambling. 1. Lottery transactions. Lottery is a game of chance and not of skill or knowledge. Where the prime motive of participant is gambling, the transaction amounts to a wager. Even if the lottery is sanctioned by the government of India, it is a wagering transaction. The only effect of such sanction is that the person responsible for running the lottery will not be punished under the Indian Penal Code. Lotteries are illegal, and even collateral transactions to it are tainted with illegality. 2. Crossword puzzles and competitions. Crossword puzzles in which prizes depend upon the correspondence of the competitor's solution with a previously prepared solution kept with the editor of a newspaper is a lottery, and therefore a wagering transaction. Crossword puzzles, picture competitions, and athletic competitions where prizes are awarded on the basis of skill and intelligence are the games of skill, and hence such competitions are valid. According to the Prize Competition Act, 1955 prize competitions in games of skill are not wagers provided. The prize money does not exceed 1,000 rupees. 3. Speculative transactions. An agreement or a share market transaction where parties intend to settle the difference between contract price and market price of certain goods or shares on a specified day is a gambling and hence void. 4. Horse race transactions where prize payable to bet winner is less than 500 rupees is a wager. Transactions resembling with wagering transaction but are not void. Chit fund. In case of a chit fund, a certain number of persons decide to contribute a fixed sum for a specified period, and at the end of a month, the amount so contributed is paid to the lucky winner of the lucky draw. 2. Commercial transactions or share market transactions. In these transactions in which delivery of goods or shares is intended to be given or taken, do not amount to wagers. 3. Games of skill and athletic competition. Crossword puzzles, picture competitions, and athletic competitions where prizes are awarded on the basis of skill and intelligence are the games of skill, and hence such competition are valid. According to the Prize Competition Act, 1955 prize competition in games of skill are not wagers provided. The prize money does not exceed 1,000 rupees. 4. A contract of insurance. A contract of insurance is a type of contingent contract and is valid under law, and these contracts are different from wagering agreements. Unit 4. Performance of a contract means fulfillment of obligations to the contract. Parties to a contract must either perform or offer to perform their respective promises the performance should be for, while obligation and part performance cannot consider as a valid performance. Types: performance may be actual or attempted. 1. Actual performance, where party to contract has done what he had undertaken to do, or either of parties has fulfilled their obligations within time and manner prescribed. 2. Offer to perform / attempted performance / tender of performance. When performance becomes due, promisor offers to perform his obligation, but promisee refuses to accept. Conditions to be satisfied for a valid tender or attempted performance. 1. It must be unconditional. 2. It must be made at proper time and place. 3. Reasonable opportunity to examine goods. 4. It must be for whole obligation. By whom a contract may be performed. 1. Promisor himself. If it was the intention of the parties that the promise should be performed by the promisor himself, such promise must be performed by the promisor. If contract involves exercise of personal skill or diligence, or which are founded on personal confidence between parties, must be performed by promisor himself. 2. Agent, where personal consideration is not the foundation of contract, promisor or his representative may employ a competent person to perform it. 3. Legal representatives. Contract which involves use of personal skill or is founded on personal consideration comes to an end on the death of the promisor unless a contrary intention appears. L.R. of deceased promisor are bound to perform, but their liability is limited to the value of property inherited from deceased. 4. Third persons. When promisee accepts performance from third person, he can't afterwards enforce it against promisor, although promisor has neither authorized nor ratified the act of third party. 5. Joint promisors. When two or more persons have made a joint promise, then unless a contrary intention appears by the contract, all such persons must jointly fulfill the promise. If any of them dies, his legal representatives must, jointly with surviving promisors, fulfill the promise. If all of them die, legal representatives of all of them must fulfill the promise jointly. Liability of joint promisor and promisee. Devolution of joint liabilities. Ordinarily, all joint promisors during their lifetime must jointly fulfill the promise. After death of any one of them, his L.R. jointly with survivor or survivors should do so. After death of last survivor, the L.R. of all the original co-promisors must fulfill promise. Any one of joint promisors may be compelled to perform. Promisee may, in absence of express agreement to contrary, compel any one or more of such joint promisors to perform the whole of the promise. Each promisor may compel contribution other joint promisor to contribute equally with himself to performance of promise, unless a contrary intention appears from contract. Sharing of loss in case of default in contribution by any one of two or more joint promisors. The remaining joint promisors must bear the loss arising from such default in equal shares. Hence, the liability is of both joint and several, in the absence of a contract to contrary. Effect of release of one joint promisor. Where two or more persons have made a joint promise, a release of one by the promisee does not discharge the other joint promisor or joint promisors. Neither does it free joint promisors, so released from responsibility to the other joint promisor or promisors. Rights of joint promisees. In case of joint promise, unless a contrary intention appears from contract, right to claim performance rests, as between them during their joint lives, and after death of any of them, with the representative of such deceased person jointly with survivor or survivors, and after death of last survivor, with representatives of all jointly. Liability of party preventing event on which contract is to take effect. When one party to contract prevents the other from performing his promise, contract becomes voidable at the option of the party so prevented, and he is entitled to compensation from other party for any loss he may sustain in consequence of non-performance of contract. Effects of failure to perform at a time. Fixed in a contract in which time is essential. When party to a contract promises to do certain thing at or before specified time, and fails to do any such thing at or before specified time, contract becomes voidable at the option of promisee. If the intention of parties was that time should be of essence of contract. Effect of such failure when time is not essential. Contract does not become voidable, but promisee is entitled to compensation from promisor for any loss occasioned to him by such failure. Effect of acceptance of performance at time other than agreed upon. If contract becomes voidable on account of promisor's failure to perform at the time agreed, and promisee accepts performance at any time other than agreed, promisee cannot claim compensation for any loss occasioned by non-performance at the time agreed, unless, at the time of acceptance, he gives notice to promisor of his intention to do so. 6. Agreement to do impossible act. Types of impossibility of performance. A. Initial impossibility. B. Subsequent impossibility. A. Initial impossibility. When parties agree upon doing of something which is impossible in itself, agreement would be void. The fact of impossibility may be and may not be known to the parties. 1. If known to parties, it would be observed that an agreement constituted quite unknown to parties may be impossible of being performed and hence void. 2. If unknown to parties, where both the promisor and the promisee are ignorant of the impossibility of performance, the contract is void. 3. If known to promisor only, where at the time of entering into a contract, the promisor alone knows about the impossibility of performance, or even if he does not know, though he should have known it with reasonable diligence, the promisee is entitled to claim compensation for any loss he suffered on account of non-performance. B. Subsequent or supervening impossibility. When performance becomes impossible or illegal by occurrence of an unexpected event or a change of circumstances beyond the contemplation of parties, the contract becomes void. In other words, sometimes performance of a contract is quite possible when it is made, but subsequently some event happens which renders it impossible or unlawful. Such impossibility is called the subsequent or supervening or post-contractual impossibility. Appropriation of payments. Sometimes a debtor owes several debts to same creditor and makes payment, which is not sufficient to discharge all the debts. In such cases, appropriation of payment applies. 1. Application of payment where debt to be discharged is indicated, where a debtor owing several distinct debts to one person makes payment either with express intimation or under circumstances implying that payment is to be applied to discharge of some particular debt. Payment, if accepted, must be applied accordingly. 2. Application of payment where debt to be discharged is not indicated, where a debtor has omitted to intimate and there are no other circumstances indicating to which debt payment is to be applied. Creditor may apply it at his discretion to any lawful debt actually due and payable to him from the debtor, where its recovery is or is not barred by the law. However, he cannot apply the payment to disputed debt. 3. Application of payment where neither party appropriates. Where neither party makes any appropriation, payment shall be applied in discharge of the debts in order of time, whether they are or are not barred by the law. If the debts are of equal standing, payments shall be applied in discharge of each proportionately. Effect of novation, rescission, and alteration of contract. If parties to a contract agree to substitute a new contract for it, or to rescind or alter it, original contract need not be performed. A. Effect of novation. Parties may substitute a new contract for the old. The old contract is discharged and consequently it need not be performed. On novation, some new contract is substituted for old contract either between the same parties or between different parties. Novation can take place only by mutual agreement between the parties. B. Effect of rescission. When parties to a contract agree to rescind it, contract need not be performed. In rescission, only the old contract is cancelled and no new contract comes to exist in its place. Both in novation and in rescission, Contract is discharged by mutual agreement. C. Effect of alteration. Where parties to a contract agree to alter it, the original contract is rescinded and need not to be performed. Terms of contract may be so altered by mutual agreement that the alteration may have the effect of substituting a new contract for the old one. Unit 5. Breach of contract. When one party fails or refuses to perform the promise or obligation entirely, or show higher unwillingness to perform, is called as breach of contract, anticipatory breach of contract, meaning it is a breach occurring before the time fixed for performance has arrived. When promiser refuses altogether to perform his promise and signifies his unwillingness even before the time for performance has arrived, it is called anticipatory breach. It may take either of following two ways. 1. Expressly by words spoken or written, and 2. Impliedly by the conduct of one of the parties. Action of promisee. Promisee may put an end to contract unless he has signified, but words or conduct, his acquiescence, assent, in its continuance. Effect of anticipatory breach. Promisee is excused from performance or further performance. Also, he gets an option, 1. To either treat the contract as rescinded and sue the other party for damages immediately without waiting until the due date of performance, or 2. Elect not to rescind, but to treat the contract as still operative and wait for the time of performance and then hold the other party responsible for non-performance. But in this case, he will keep the contract alive for benefit of other party as well as his own. And guilty party may still perform his part of contract if he so decides, and can also take advantage of any supervening impossibility which may have effect of discharging the contract. Anticipatory breach of contract checkmark meaning. It is a breach occurring before the time fixed for performance has arrived. When promiser refuses altogether to perform his promise and signifies his unwillingness even before the time for performance has arrived, it is called anticipatory breach. It may take either of following two ways. 1. Expressly by words spoken or written, and 2. Impliedly by the conduct of one of the parties. Check action of promisee. Promisee may put an end to contract unless he has signified, but words or conduct, his acquiescence, assent, in its continuance. Checkmark effect of anticipatory breach. Promisee is excused from performance or further performance. Also, he gets an option, 1. To either treat the contract as rescinded and sue the other party for damages immediately without waiting until the due date of performance, or 2. Elect not to rescind, but to treat the contract as still operative and wait for the time of performance and then hold the other party responsible for non-performance. But in this case, he will keep the contract alive for benefit of other party as well as his own, and guilty party may still perform his part of contract if he so decides, and can also take advantage of any supervening impossibility which may have effect of discharging the contract. B. Actual breach of contract meaning. It is a case of refusal to perform the promise on the scheduled date. Parties are bound to perform, but when one breaks the contract by refusing to perform his promise, he is said to have committed a breach. Actual breach of contract may be committed, 1. At the time when the performance of the contract is due to. During the performance of the contract when one party fails or refuses to perform his obligation. Remedies for breach of contract. 1. Suit for damages. On breach of contract, the party that suffers is entitled to receive compensation for any loss or damage caused to them by the breach. Compensation can be claimed for any loss or damage which 1. Naturally arises in the usual course of events, or which 2. The party knew when they entered into contract it as likely to result from breach. Special damage can be claimed only on a previous notice, but the party suffering is bound to take reasonable steps to minimize the loss. No compensation is payable for any remote or indirect loss. I. Ordinary damages. When contract has been broken, party who suffers by such breach is entitled to receive compensation for any loss or damage which naturally arose in usual course of things, or which parties know, when they made the contract, to be likely to result from breach of it. Such compensation is not to be given for any remote and indirect loss or damage. 2. Special damages. Where a party to a contract receives a notice of special circumstances affecting the contract, he will be liable not only for damages arising naturally and directly from the breach, but also for special damages. 3. Vindictive or exemplary damages. Checkmark. These damages may be awarded only in 2 cases. A. For breach of promise to marry because it causes injury to his or her feelings. And B. For wrongful dishonor by a banker of his customer's check. Businessman whose credit has suffered will get it even if has sustained no pecuniary monetary loss. But a non-trader cannot get heavy damages in like circumstances, unless proved as special damages. 4. Nominal damages. It is awarded where plaintiff has proved that there has been a breach of contract, but he has not in fact suffered any real damage. Awarded just to establish right to decree. The amount may be a rupee or even 10 pies. V. Damages for deterioration caused by delay. In such cases, damages can be recovered from carrier even without notice. Deterioration not only implies physical damages to goods, but also loss of special opportunity for sale. 6. Prefixed damages. Parties to a contract stipulate at the time of its formation that on a breach, a certain amount will be payable as damages. It may be either liquidated damages or a penalty. The aggrieved party is entitled to receive reasonable compensation, not exceeding the amount so named in case of breach from the party at fault. Penalty and liquidated damages, meaning parties to a contract may provide the amount of compensation payable in case of failure to perform the contract. It may be penalty or liquidated damages. Liquidated damages, sum fixed, represents a genuine pre-estimate by parties of the loss. It is liquidated damages which, in the opinion of parties, will compensate for breach. Penalty, sum fixed in the contract, is unreasonable and is used to force the other party to perform the contract. It is penalty. Such a clause of disregarded and the injured party cannot recover more than the actual loss. 2. Rescission of contract. When a contract is broken by one party, the other party may treat the contract as rescinded. In such a case, he is absolved of all his obligations under the contract and is entitled to compensation for any damages that he might have suffered. 3. Quantum meruit. Meaning, if one person has rendered service to another in circumstances which indicate an understanding between them that it is to be paid for, although no particular remuneration fixed, the law will infer a promise to pay, that is, as much as the party doing service has deserved. If party injured by breach had at time of breach done part, but not all of work which he is bound to do under contract, shall be compensated for the value of the work done. For the application of this doctrine, 2 conditions must be fulfilled. 1. It is only available if the original contract has been discharged. 2. The claim must be brought by a party not in default. Object of quantum meruit. Recompensate the party or person for value of work which he has done. Damages are compensatory in nature, while quantum merit is restitutory. It is but reasonable compensation awarded on implication of a contract to remunerate. The claim for quantum meruit arises in the following cases. A. When an agreement is discovered to be void, or when a contract becomes void. B. When something is done without any intention to do so gratuitously. C. Where there is an express or implied contract to render services, but there is no agreement as to remuneration. D. When one party abandons or refuses to perform the contract. E. Where a contract is divisible and the party not in default has enjoyed the benefit of part performance. F. When an indivisible contract for a lump sum is completely performed but badly, the person who has performed the contract can claim lump sum, but other party can make a deduction for bad work. 4. Suit for specific performance. Where damages are not an adequate remedy, court may in its discretion on a suit for specific performance direct party in breach, to carry out his promise according to terms of contract. 5. Suit for injunction. Where a party to a contract is negating the terms of a contract, court may by issuing an injunction orders restrain him from doing what he promised not to do. Party rightfully rescinding contract, entitled to compensation for any damage which he has sustained through non-fulfillment of the contract. Unit 6. Contingent contract. Contract may be absolute, complete, or contingent. An absolute contract is one where the promisor undertakes to perform the contract in any event without any condition. A contract to do or not to do something, if some event, Collateral to such contract does or does not happen is known as contingent contract. Contracts of insurance, indemnity, and guarantee fall under this category. Meaning of collateral event: an event which is neither a performance directly promised as part of contract, nor the whole of the consideration for a promise. Essentials of a contingent contract: A. The performance of a contingent contract would depend upon the happening or non-happening of some event or condition. The condition may be precedent or subsequent. B. The event referred to as collateral to the contract. The event is not part of the contract. The event should be neither performance promised nor a consideration for a promise. C. The contingent event should not be a mere will of the promisor. The event should be contingent in addition to being the will of the promisor. D. The event must be uncertain. Where the event is certain or bound to happen, the contract is due to be performed. Then it is a not contingent contract. Rules relating to enforcement. A. Enforcement of contracts contingent on an event happening, enforceable, where a contingent contract is made to do or not to do anything if an uncertain future event happens. It cannot be enforced by law unless and until that event has happened. If the event becomes impossible, such contracts become void. B. Enforcement of contracts contingent on an event not happening, enforceable, where a contingent contract is made to do or not do anything if an uncertain future event does not happen. It can be enforced only when the happening of that event becomes impossible and not before. C. A contract would cease to be enforceable, unenforceable, if it is contingent upon conduct of a living person and when that living person does something to make the event or conduct as impossible of happening. D. Contingent on happening of specified event within the fixed time, enforceable. Contingent contracts to do or not to do anything, if a specified uncertain event happens within fixed time. If at the expiration of time fixed such event has not happened or becomes impossible before time fixed, it becomes void. E. Contingent on specified event not happening within fixed time. Enforceable. Contingent contracts to do or not to do anything, if a specified uncertain event does not happen within a fixed time, may be enforced when the time fixed has expired, and such event has not happened, or before the time fixed has expired, if it becomes certain that such event will not happen. F. Contingent on an impossible event. Enforceable. Contingent contracts to do or not to do anything, if an impossible event happens, are void, whether the impossibility of event is known or not, to the parties to agreement at the time when it is made. Quasi-contracts. A valid contract must contain certain essential elements, but sometimes the law implies a promise imposing obligations on one party and conferring right in favor of the other, even in the absence of essential elements of valid contract. Such cases are not contract in the strict sense, but court recognizes them as relations resembling those of contracts and enforces them as if they were contracts. These are known as quasi-contracts, as they create same obligations as in the case of regular contract. It is also called as certain relation resembling those created by contracts. Quasi or constructive contract are based on principles of equity, justice, and good conscience. Salient features/principles of quasi-contracts. A. Such a right is always a right to money, and generally to a liquidated, estimated sum of money. B. It does not arise from any agreement of parties concerned, but is imposed by law and oisai. This right is available not against all world, but against a particular person or persons only. Cases deemed as quasi-contracts. A. Claim for necessaries supplied to persons incapable of contracting. If a person, incapable of entering into a contract, or anyone whom he is legally bound to support, is supplied with necessaries suited to his condition in life, the person who has furnished such supplies is entitled to be reimbursed from property of such incapable person. To establish the claim, supplier must prove not only that the goods were supplied to the person who was minor or a lunatic, but also that they were suitable to his actual requirements at the time of sale and delivery to establish his claim. B. Payment by an interested person. Person who is interested in the payment of money which another is bound by law to pay, and who therefore pays it, is entitled to be reimbursed by the other. C. Obligation of person enjoying benefits of non-gratuitous act. If a person lawfully does anything for another, or delivers anything to him not intending to do so gratuitously, free, and such other person enjoys the benefit thereof, such other person is bound to pay compensation or to restore the thing so done or delivered. Plaintiff must prove that A. That he had done the act or had delivered the thing lawfully, B. That he did not do so gratuitously, and C. That the other person enjoyed the benefit. D. Responsibility of finder of goods. Person who finds goods belonging to another and takes them into his custody is subject to same responsibility as if he were a bailee. Thus, a finder of lost goods has a E to take proper care of the property as man of ordinary prudence would take. B. He has no right to appropriate the goods, and C. He must restore the goods if the owner is found. E. Money paid by mistake or under coercion. Person to whom money has been paid or anything delivered by mistake or under coercion must repay or return it. Every kind of payment of money or delivery of goods for every type of mistake is recoverable. Unit 7. Contract of indemnity. Meaning of indemnity: security against loss, assurance, or to make good the loss, restore, or to compensate the party who has suffered some loss. Meaning of contract of indemnity: a contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself, or by the conduct of any other person. Parties in case of contract of indemnity: A. Party who promises to indemnify/save the other party from loss. Indemnifier. B. Party who is promised to be saved against the loss, indemnified, or indemnity holder. The definition of indemnity restricts the scope as it covers only the loss caused by A. The conduct of the promiser himself, or B. The conduct of any other person. Thus, loss occasioned by an accident or an act of God/natural event is not covered. Mode of contract of indemnity: A. Express, when a person expressly promises to compensate the other from loss. B. Implied, when it is to be inferred from conduct of parties or from circumstances. Contract of indemnity must fulfill all the essentials of a valid contract. Contract of fire insurance or marine insurance is always a contract of indemnity. But there is no contract of indemnity in case of contract of life insurance. Rights of indemnity. Holder when sued. Promisee acting within the scope of his authority is entitled to recover from promiser/indemnifier A. all damages which he may be compelled to pay in any suit. B. All costs which he may have been compelled to pay in bringing/defending the suit, and E.C. all sums which he may have paid under the terms of any compromise of suit. When does the liability of an indemnifier commence? Liability of an indemnifier commences as soon as the liability of the indemnity holder becomes absolute and certain. Contract of guarantee. Meaning, it is a contract to perform the promise made or discharge the liability of a third person in case of his default. Parties involved in a contract of guarantee: A. Surety, person who gives the guarantee. B. Principal debtor, person in respect of whose default the guarantee is given. C. Creditor, person to whom the guarantee is given. Contract of guarantee is a tripartite agreement between principal debtor, creditor, and surety. A. A principal contract between the principal debtor and the creditor. B. A secondary contract between the creditor and the surety. C. An implied contract between the surety and the principal debtor, whereby principal debtor is under an obligation to indemnify surety, if surety is made to pay or perform. Essential features/requisites of a valid guarantee. 1. Purpose. Guarantee being to secure the payment of a debt, and existence of recoverable debt is necessary. If there is no principal debt, there can be no valid guarantee. 2. Consideration. Contract of guarantee should be supported by consideration. Without consideration, it is void. However, there is no need for a direct consideration between surety and creditor. Consideration received by principal debtor is sufficient consideration to surety for giving the guarantee, but past consideration is no consideration. Even if the principal debtor is incompetent to contract, guarantee is valid. But if surety is incompetent to contract, the guarantee is void. 3. Existence of a liability. There must be an existing liability or a promise whose performance is guaranteed, which must be enforceable by law and not time-barred. 4. No misrepresentation or concealment. Guarantee if obtained using misrepresentation made by creditor or with his knowledge and assent, concerning a material part of the transaction, is invalid. Guarantee which the creditor has obtained by means of keeping silence as to material circumstances is invalid. 6. Joining of the other co-sureties. Where a person gives a guarantee upon a contract that creditor shall not act upon it until another person has joined in it as co-surety, the guarantee is not valid if that other person does not join. Guarantee by a surety is not valid if a condition imposed by a surety is that some other person must also join as a co-surety, but such other person does not join as a co-surety. Types of guarantees. 1. Specific guarantee. Guarantee which extends to a single debt/specific transaction. Surety's liability comes to an end when the guaranteed debt is duly discharged or the promise is duly performed. 2. Continuing guarantee. Guarantee which extends to a series of transactions. Surety's liability continues until the revocation of the guarantee. Essence, it applies to any number of transactions and makes the surety liable for unpaid balance at the end of guarantee. Nature and extent of surety's liability. 1. Liability of surety is coextensive with principal debtor unless otherwise provided in contract. 2. Liability of surety is of secondary nature as he is liable only on default of principal debtor. 3. If debtor can't be liable on account of any defect in document, liability of surety also ceases. 4. Creditor may choose to proceed against a surety first unless agreement to contrary. Liability of two persons, primarily liable, not affected. By arrangement between them that one shall be surety on other's default. Where two persons contract with a third person to undertake a certain liability, and also contract with each other that one of them shall be liable only on default of other, the liability towards third person is not affected even if third party is aware about its existence. Discharge of a surety. Surety is said to be discharged when his liability as surety comes to an end. Modes of discharge of surety are discussed below. By revocation of the contract of guarantee. 1. Revocation of continuing guarantee by notice. Continuing guarantee may at any time be revoked by the surety as to future transactions by notice to the creditors. Once revoked, surety is not liable for any future transaction. However, surety is liable for all transactions that happened before notice was given. Specific guarantee can be revoked only if liability to the principal debtor has not accrued. 2. Revocation of continuing guarantee by surety's death. Death of surety operates as revocation of continuing guarantee as to future transactions taking place after death of surety unless contract to contrary. However, surety's estate remains liable for past transactions taken place before death. 3. By novation. Surety under original contract is discharged if a fresh contract is entered into either between the same parties or between the other parties. Consideration being the mutual discharge of the old contract. B. By conduct of the creditor. 1. By variance in terms of contract. Where there is any variance in terms of contract between principal debtor and creditor without surety's consent, it would discharge surety for all transactions subsequent to such variance. 2. By release or discharge of principal debtor. Surety is discharged if creditor enters into a fresh/new contract by which principal debtor is released, or does any act or omission legal consequence of which is discharge of principal debtor. 3. Discharge of surety when creditor compounds or gives time or agrees not to sue. A contract between the creditor and principal debtor by which creditor makes a composition or promises to give time or promises not to sue. The principal debtor discharges surety unless surety assents to such contract. 1. Composition. Creditor makes a composition with the principal debtor without consulting surety. The latter is discharged. Composition involves variation of the original contract. Therefore, surety is discharged. 2. Promise to give time. When the time for payment comes, the surety has the right to require the principal debtor to pay off the guaranteed debt. It is a duty of the creditor not to allow the principal debtor more time for payment. 3. Promise not to sue. If the creditor under an agreement with the principal debtor promises not to sue him, surety is discharged. Reason. Surety is entitled to call upon creditor at any time for payment of debt when it is due, and this right is positively violated when creditor promises not to sue principal debtor. 4. By creditor's act or omission impairing surety's eventual remedy. If creditor does any act which is inconsistent with rights of surety, or omits to do any act which his duty to the surety requires him to do, and the eventual remedy of surety against principal debtor is thereby impaired, damaged, the surety is discharged. Cases where surety is not discharged. 1. Surety not discharged when agreement made with third person to give time to principal debtor. 2. Mere forbearance on the part of creditor to sue or to enforce any other remedy does not discharge the surety unless contract to contrary. By the invalidation of contract of guarantee. 1. Guarantee obtained by misrepresentation. 2. Guarantee obtained by concealment. 3. Guarantee on contract that creditor shall not act on it until co-surety joins. Rights of a surety. Following rights are available to a surety. Right against the creditor. 1. Surety's right to benefit of creditor's securities. Surety is entitled to the benefit of every security which the creditor has against principal debtor at the time when contract of suretyship is entered into, whether surety knows of existence of such security or not. If creditor loses or without consent of surety, parts with such security, surety is discharged to the extent of the value of security. 2. Right to set off. If creditor sues surety for payment of principal debtor's liability, surety may have the benefit of set off, if any, that the principal debtor had against the creditor. 3. Right to share reduction. Surety has right to claim proportionate reduction in his liability if principal debtor becomes insolvent. B. Right against the principal debtor. 1. Rights of subrogation. Where a guaranteed debt has become due, or in case of default by principal debtor to perform, surety, upon payment or performance, is invested with all the rights which the creditor had against the principal debtor. This right is known as right of subrogation. The surety steps into the shoes of creditor. 2. Implied promise to indemnify surety. In every contract of guarantee, there is an implied promise by principal debtor to indemnify the surety. The surety is entitled to recover from the principal debtor whatever sum he has rightfully paid under the guarantee, but not sums which he paid wrongfully. C. Rights against co-sureties. 1. Co-sureties liable to contribute equally. When same debt or duty is guaranteed by two or more persons are called co-sureties. Co-sureties liable to contribute equally. Each surety is liable to contribute equally for discharge of whole debt or part of debt remains unpaid by debtor unless otherwise agreed. 2. Liability of co-sureties bound in different sums. Principle of equal contribution is subject to maximum limit fixed by a surety to his liability. Co-sureties who are bound in different sums are liable to pay equally as far as the limits of their respective obligations permit. What is bailment? Bailment is the delivery of goods by one person to another for some purpose, upon a contract that the goods shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the person delivering them. Parties to bailment. A. Bailor, the person delivering the goods. B. Bailee, the person to whom the goods are delivered. Essential elements. 1. Contract bailment is based upon a contract which may be express or implied. No consideration is necessary to create a valid contract of bailment. 2. Delivery of goods. It involves delivery for some purposes. Bailment is only for movable goods and never for immovable goods or money. The delivery of the possession of goods is of the following kinds. 1. Actual delivery. When goods are physically handed over to the bailee by the bailor. 2. Constructive delivery. Delivery is made by doing anything that has effect of putting goods in the possession of bailee or person authorized to hold them on his behalf. 3. Purpose. The goods are delivered for some purpose. The purpose may be express or implied. 4. Possession. In bailment, possession of goods changes either by physical or constructive delivery, but it doesn't lead to change of ownership and bailor continues its ownership. Change of possession does not lead to change of ownership. Where a person is in custody without possession, he does not become a bailee. Note: in case of custody, there is no control, but in case of possession, there is controls of the goods available with the bailee. 5. Return of goods. Bailee is obliged to return the goods physically to the bailor. Returned in same form as given or may be altered as per bailor's direction. Exchange of goods should not be allowed, even not those of higher value. Types of bailment. On the basis of benefit, bailment can be classified into 3 types. 1. For the exclusive benefit of bailor. 2. For exclusive benefit of bailee. 3. For mutual benefit of bailor and bailee. On the basis of reward, bailment can be classified into 2 types. 1. Gratuitous bailment. Gratuitous means free of charge. It is one when the provider of service does it gratuitously, that is free of charge for the exclusive benefits of bailor or bailee. 2. Non-gratuitous bailment. Non-gratuitous bailment means where both the parties get some benefit, that is bailment for the benefit of both bailor and bailee. Duties of a bailor. 1. Bailor's duty to disclose faults in goods bailed. A. Gratuitous bailment. Bailor is bound to disclose faults in goods bailed, of which the bailer is aware and which materially interfere with use of them or expose the bailee to extraordinary risks. If he doesn't disclosure, responsible for damage arising to bailee directly from faults. B. Non-gratuitous bailment. If goods are bailed for hire, bailer is responsible for such damage, whether he was or was not aware of existence of such faults. Sometimes goods bailed are of dangerous nature. In such cases, it is the duty of the bailer to disclose the nature of goods. 2. Duty to pay necessary expenses. A. Gratuitous bailment. Bailer shall repay to bailee the necessary expenses incurred by him and any extraordinary expenses incurred by him for the purpose of bailment. B. Non-gratuitous bailment. Bailer is liable to pay extraordinary expenses only. 3. Duty to indemnify the bailee for premature termination. Bailer must compensate the bailee for the loss or damage suffered by bailee that is in excess of the benefit received, where he had lent the goods gratuitously and decides to terminate the bailment before the expiry of the period of bailment. 4. Bailer's responsibility to bailee. A. Indemnify for any loss. Bailer to indemnify bailee for any loss which bailee may sustain by reason that the bailer was not entitled to make the bailment or to receive back the goods or to give directions respecting them. Defective title in goods. B. Receive back the goods. Bailer must receive back the goods when the bailee returns them after the time of bailment has expired or purpose of bailment has been accomplished. If bailer refuses to take delivery when offered at proper time, bailee can claim compensation for all necessary expenses incurred for the safe custody. Duties of a bailee. 1. Take reasonable care of the goods. Bailee is bound to take as much care of the goods bailed to him as a man of ordinary prudence would, under similar circumstances, take care of his own goods of the same bulk, quality, and value as the goods bailed. Exception. Bailee when not liable for loss, etc., of thing bailed. Bailee is not responsible for loss, destruction, or deterioration of the thing bailed if he has taken reasonable care unless special contract made. 2. Not to make inconsistent use of goods. If bailee makes any use of goods bailed which is not according to terms and conditions of bailment, he is liable to compensate bailer for any loss or destruction of goods. Contract of bailment is voidable at the option of the bailer if the bailee does not use the goods according to the terms and conditions of bailment. 3. Not to mix the goods. If bailee mixes the goods bailed with his own goods, with the consent of bailer, both the parties shall have an interest in proportion to their respective shares in the mixture thus produced. If mixes without consent of bailer but the goods can be separated or divided, property in the goods remains in the parties respectively. But bailee is bound to bear the expense of separation or division and any damage arising from the mixture. If mixes without consent of bailer, and in such a manner that it is impossible to separate the goods bailed from other goods and to deliver them back, bailer is entitled to be compensated by bailee for loss of the goods. 4. Return the goods. It is the duty of bailee to return, or deliver according to the bailer's directions, the goods bailed without demand, as soon as the time for which they were bailed has expired, or the purpose for which they were bailed has been accomplished. If, by the default of the bailee, the goods are not returned, delivered, or tendered at the proper time, he is responsible to the bailer for any loss, destruction, or deterioration of the goods from that time. 5. Return and accretion from the goods. Bailee is bound to deliver to the bailer, or according to his directions, any increase or profit which may have accrued from the goods bailed unless contract to contrary. 6. Not to set up adverse title. Bailee must not set up a title adverse to that of the bailer. He must hold the goods on behalf of and for the bailer. He cannot deny the title of the bailer. Rights of a bailer. 1. Right to terminate the bailment. Contract of bailment is voidable at the option of the bailer. If the bailee does any act with regard to the goods bailed, inconsistent with the conditions of bailment. 2. Right to demand back the goods. In gratuitous bailment, bailer can demand back the goods at any time even before the expiry of the time fixed or achievement of the object. Due to premature return of goods, if bailee suffers any loss, which is more than the benefit actually obtained by him, bailer has to compensate the bailee. 3. Right to file a suit against a wrongdoer. 4. Right to sue the bailee. The bailer has a right to sue the bailee for enforcing all the liabilities and duties of him. 5. Right to compensation. If any damage is caused to goods bailed because of unauthorized use or unauthorized mixing of goods, Bailor has a right to claim compensation for the same. Rights of a bailee. 1. Right to deliver the goods to any one of the joint bailors. If several joint owners bailed the goods, bailee has a right to deliver them to any one of the joint owners unless there was a contract to the contrary. 2. Right to indemnity. Indemnification for any loss arising to him by reasons that bailor was not entitled to make the bailment or to receive back the goods, or to give directions in respect to them. If bailor has no title to goods, and bailee delivers them back in good faith, or according to directions of bailor, bailee shall not be responsible to owner for such delivery. Bailee can also claim all necessary expenses incurred for gratuitous bailment. 3. Right to claim compensation in case of faulty goods. Bailee is entitled to receive compensation for any loss caused to him due to failure of bailor to disclose any faults in the goods known to him. If bailment is for hire, bailor will be liable, even though not aware of existence of faults. 4. Right to claim necessary expenses. Gratuitous bailment. Bailor shall repay the necessary expenses incurred by him, and any extraordinary expenses incurred by him for the purpose of bailment. 5. Right to apply to court to decide the title to the goods. If the goods bailed are claimed by the person other than the bailor, the bailee may apply to the court to stop its delivery and to decide the title to the goods. Rights of bailor and bailee against any wrongdoer. Suit by bailor and bailee against wrongdoers. If a third person wrongfully deprives the bailee of the use or possession, or does any injury to goods bailed, bailee is entitled to use such remedies as the owner might have used in the like case if no bailment had been made. Either bailor or bailee may bring a suit against a third person for such deprivation or injury. Apportionment of relief or compensation obtained by such suits. Whatever is obtained by way of relief or compensation in such suit shall be dealt with according to the respective interests of bailor and bailee. Termination of bailment. 1. On expiry of stipulated period. If the goods were given for a stipulated period, the contract of bailment shall terminate after the expiry of such period. 2. On fulfillment of the purpose. If the goods were delivered for a specific purpose, a bailment shall terminate on the fulfillment of that purpose. 3. By notice. A. If bailee acts in a manner which is inconsistent with the terms of bailment, bailor can terminate the contract of bailment by giving a notice to bailee. B. Gratuitous bailment can be terminated at any time by giving a notice to bailee. However, termination should not cause loss to bailee in excess of benefit derived by him. In case loss exceeds the benefit, bailor must compensate bailee for such a loss. 4. By death. Gratuitous bailment terminates upon the death of either bailor or bailee. 5. Destruction of the subject matter. Bailment is terminated if the subject matter of bailment is destroyed, or there is a change in the nature of goods which makes it impossible to be used for bailment. Finder of lost goods. Right of finder of lost goods may sue for specific reward offered. A person who finds some goods which do not belong to him is called finder of the goods. It is the duty of finder of goods to find the true owner and surrender the goods to him. Finder has no right to sue the owner for compensation for trouble and expense voluntarily incurred in finding the owner and preserving the goods found. But he has a right to retain the goods until he receives such compensation. If the owner has offered a specific reward on the lost goods, finder may sue the owner for such reward and may retain the goods until then. When finder of thing commonly on sale may sell it. A. If the owner cannot be found with reasonable diligence, or if he refuses to pay the lawful charges of the finder may sell it. B. When the thing is in danger of perishing or of losing the greater part of its value. Or C. When the lawful charges of finder in respect of the thing found amount to 2/3 of its value. Right of lien. Lien is the right of a person to retain the goods belonging to another until his claim is satisfied or some debt due to him is repaid. Types of lien. Particular lien. It is a right to retain only the particular goods in respect of which the claim is due. If bailee has rendered any service involving exercise of labor or skill in respect of the goods bailed, he has right to retain them until he receives due remuneration for services rendered for goods bailed, unless contract to contrary. General lien. It is a right to retain the goods not only for demands arising out of the goods retained, but for a general balance of account in favor of certain persons, in the absence of a contract to the contrary. This right is available to bankers, factors, wharfingers, policy brokers, and attorneys of law. In case of general lien, The goods cannot be sold but can only be retained for dues. The right of lien can be waived through a contract, pledge, meaning bailment of goods. As security for payment of a debt or performance of a promise is called pledge. Parties in case of pledge. A. Pawner. The bailer is in this case called the pawner. B. Pawnee. The bailee is called the pawnee/pledgee. Essentials of contract of pledge. Since pledge is a special kind of bailment, therefore all the essentials of bailment are also the essentials of the pledge. Apart from that, the other essentials of the pledge are A. There shall be a bailment for security against payment or performance of the promise. B. The subject matter of pledge is goods. C. Goods pledged for shall be in existence. D. There shall be the delivery of goods from pledger to pledgee. Rights of pawnee/pledgee. 1. Right to retain the pledged goods. Pawnee may retain the goods pledged for payment or interest of debt or performance of promise, and for all necessary expenses incurred for possession or preservation of goods. 2. Right to retention of subsequent debts. Pawnee can retain the goods pledged for any debt or promise other than the debt or promise for which they are pledged, only if there is a contract to this effect. 3. Pawnee's right to extraordinary expenses incurred. Pawnee is entitled to receive extraordinary expenses incurred for preservation of goods. However, he does not have the right to retain the goods for such expenses, but he can sue the pawner for such expenses. 4. Pawnee's right where pawner makes default. If pawner makes default in payment of debt or performance or promise in stipulated time, Pawnee has the following rights. 1. Pawnee may bring a suit against pawner upon the debt or promise and retain the goods pledged as a collateral security. Or 2. He may sell the thing pledged on giving the pawner reasonable notice of sale. If proceeds of such sale are less than amount due, pawner is still liable for balance. If proceeds of sale are greater than amount due, Pawnee shall pay the surplus to the pawner. Rights of a pawnor. As the bailer of goods, pawnor has all the rights of the bailer. Along with that, he also has 1. Right to redeem. If pawnor makes default in payment of debt or performance of promise at the stipulated time, he may redeem the goods pledged at any subsequent time before the actual sale of them, but he must pay in addition any expenses which have arisen from his default. Duties of the pawnee. 1. Duty to take reasonable care of the pledged goods. 2. Duty not to make unauthorized use of pledged goods. 3. Duty to return the goods when the debt has been repaid or the promise has been performed. 4. Duty not to mix his own goods with goods pledged. 5. Duty not to do any act which is inconsistent with the terms of the pledge. 6. Duty to return accretion to the goods, if any. Duties of a pawner. 1. Pawnor is liable to pay the debt or perform the promise as the case may be. 2. To compensate pawnee for any extraordinary expenses incurred for preserving the goods. 3. To disclose all the faults which may put the pawnee under extraordinary risks. 4. Indemnify the pawnee for loss occurred to pawnee due to defect in pawner's title to goods. 5. If the pawnee sells the good due to default by the pawner must pay the deficit. Pledge by non-owners, meaning, ordinarily, owner or any person authorized by him can pledge the goods. But law has recognized certain exceptions. 1. Pledge by mercantile agent. Mercantile agent in the possession of goods or document of title with the consent of owner can pledge them while acting in the ordinary course of business. Such pledge shall be valid as if were made with authority of the owner of goods, provided pawnee acted in good faith and had no notice that pawner has no authority to pledge. 2. Pledge by person in possession under voidable contract. When pawner has obtained possession of goods pledged by him under a voidable contract, but the contract has not been rescinded at the time of pledge, the pawnee acquires a good title, provided he acts in good faith and without notice of pawner's defect of title. 3. Pledge where pawner has only a limited interest. Where a person pledges goods in which he has only a limited interest, that is, pawner is not the absolute owner of goods, the pledge is valid to the extent of that interest. 4. Pledge by a co-owner in possession. Where goods are owned by many person and with the consent of other owners, goods are left in possession of one of the co-owners. Such a co-owner may make a valid pledge. 5. Pledge by seller or buyer in possession. a seller in whose possession the goods have been left after sale, or a buyer who, with the consent of seller, obtains possession before sale, can make a valid pledge, provided pawnee acts in good faith and has no knowledge of defect in title of pawner. What is agency? Agent, a person employed to do any act or to represent another in dealing with third persons, principal, a person for whom such act is done or who is so represented. Appointment and authority of agents, who may employ an agent. Any person who has attained majority according to the law to which he is subject and who is of sound mind may employ an agent. Thus, a minor or a person of unsound mind cannot appoint an agent. Who may be an agent? Any person may become an agent that is even a minor or a person of unsound mind. But as a rule of caution, a minor or a person of unsound mind should not be appointed as an agent because he is incompetent to contract, and in case of his misconduct or negligence, principal shall not be able to proceed against him. Consideration not necessary. No consideration is necessary to create an agency. Acceptance of office of an agent is regarded as a sufficient consideration. Extent of agent's authority. A. Agent's authority in normal circumstances. Agent having an authority to do an act has authority to do every lawful thing which is necessary in order to do such act. Agent having an authority to carry on a business has authority to do every lawful thing necessary for the purpose, or usually done in the course, of conducting such business. Agent's authority in an emergency. Agent has authority in an emergency to do all such acts for the purpose of protecting his principal from loss as would be done by a person of ordinary prudence, in his own case, under similar circumstances. To constitute a valid agency in an emergency, following conditions must be satisfied. 1. Agent should not be in a position or have any opportunity to communicate with his principal within the time available. 2. There should be actual and definite commercial necessity for agent to act promptly. 3. Agent should have acted bona fide and for the benefit of the principal. 4. Agent should have adopted the most reasonable and practicable course under the circumstances. And 5. Agent must have the possession of principal's goods which are subject of contract. Duties and obligations of an agent. 1. Duty to follow instructions or customs. Agent is bound to conduct business according to the direction given by principal. Absence of any such directions. Follow customs in doing business of the same kind. Acts otherwise. Indemnify the principal. If any loss is sustained, and if any profit accrues, he must account for it. 2. Duty of reasonable care and skill. Agent is bound to conduct business with as much skill as is generally possessed by persons engaged in similar business, unless the principal has notice of his want of skill. Agent is always bound to act with reasonable diligence and to use skills as he possesses. He must compensate to his principal in respect of direct consequences of his own neglect, want of skill or misconduct, but not in respect of indirect or remote loss of damage. 3. Duty to render proper accounts. Agent is bound to render proper accounts to his principal on demand. Rendering accounts doesn't mean showing accounts, but accounts supported by vouchers. 4. Agent's duty to communicate with principal. Duty of an agent, in cases of difficulty, to use all reasonable diligence in communicating with his principal and in seeking to obtain his instructions. 5. Duty not to deal on his own account. Agent should not deal on his own account without first obtaining the consent of the principal. Otherwise, the principal may a. Repudiate the transaction. B. Claim from the agent any benefit which may have resulted to him from the transaction. 6. Duty not to make secret profits. Duty of an agent not to make any secret profit as his relationship with principal is of fiduciary nature, and this requires absolute good faith in the conduct of agency. Secret profit means any advantage obtained by the agent over and above his agreed remuneration, and which he would not have been able to make but for his position as agent. 7. Duty not to delegate. Agent cannot lawfully employ to perform acts which he has expressly or impliedly undertaken to perform personally, unless by ordinary custom of trade or nature of agency. Sub-agent must be employed.